Mr. Bacon. You'll have to unmute, Mr. Bacon.
My apologies. Good morning, Chief Justice O'Connor, and may it please the court. I'm Steve Bacon, and I'm here today on behalf of the City of Centerville, Ohio. And with the court's permission, I'd like to reserve 4 minutes for rebuttal. The primary question in this case concerns when a municipality is to be considered a victim of crime and entitled to restitution under Ohio law. Now, this question is answered by 2 provisions of Ohio's Constitution, and they're both set forth in Article 1, Section 10A concerning victims' rights. Now, these provisions were overwhelmingly approved by Ohio voters in November of 2017 as a part of the Marsy's Law Crime Victim Rights Initiative. The first of these 2 provisions defines who's a victim and who is entitled to the mandatory rights set forth in Ohio's Bill of Rights for victims of crime. And that definition is set forth in Section 10A at letter D. And it states that a victim means a person against whom the offense or criminal act is committed, or who's directly and proximately harmed by the commission of the offense or act. The second of the 2 provisions addressing this question is set forth in Article 1, Section 10A at letter A, item 7, and there's a list of the enumerated rights of victims, and states that a victim shall have a right to full and timely restitution from the person who committed the crime. Now, these 2 provisions taken together effectively mandate the proposition of law offered by the city, that a municipality qualifies as a victim under the Ohio Constitution's Bill of Rights, Section 10A of Article 1, and known as Marsy's Law, and is entitled to full and timely restitution when it's directly and proximately be harmed by the commission of a criminal offense or an act. Now, under this proposition of law and in the context of this case, this means that Centerville would qualify as a victim of crime and would be entitled to restitution for harm it suffered as a direct and proximate result of Michael Knabb's criminal acts. Now, Mr. Knabb was convicted in the trial court of 2 crimes: making a false report to a law enforcement agency and improper use of the 911 system. These crimes arose, or these convictions arose, from an April 3rd, 2018 incident in which Mr. Knabb called the 911 and reported to the Centerville Police Department that there was an active shooter in his home, that individuals were injured. Well, it turned out these statements were false. There was no shooter. There were no injured people, but Centerville's a relatively small city. And so this crime required it to allocate all of its resources to respond to this call. So the trial court awarded restitution to the city, and I believe it was under the improper use of the 911 system conviction, for the cost of officers' time in responding to that call.
Counsel, I wonder if you could respond to the question addressed in the Court of Appeals opinion, which is, in this situation, the city was paying its officers whether they responded to that call or not. And so even if we would agree with you that under some circumstances, there might, the word person might be able to include an entity other than a natural person, why would it be extended here where the city was acting in its governmental capacity, and the costs that it was incurring would be costs that they would normally incur?
Well, when you look at the first part of your question, I think that concerns, whether the cost would have, been incurred otherwise in that. And I think when you look at this, there were not just the regular patrolmen who were out on their duties, but in this instance, there were also detectives who have other duties. There were also command staff. There were multiple people brought in that were taken away from their other normal and regular duties and required to serve and respond to this particular call. I think there were 11 personnel and a dispatcher devoted to this one thing, and those people normally have other duties or normally performing other jobs, and the city lost those resources. As to the issue of governmental versus proprietary function, I think you have to look at the fact that, as provisions of Ohio's constitutions, Marsy's Law is the supreme law of Ohio. It's an expression of the will of the people, and I think it expressly states that it supersedes and that it is self-executing. So when the Court of Appeals was looking to prior case law interpreting the restitution statute, it shouldn't have been. It should have been solely looking to the definition set forth in Marsy's Law, because that prior law had been superseded.
Counsel, Counsel, are you saying that the standard of finding a loss is no longer to be employed here? You just look at the definition of victim and that's what controls?
I would say that the standard for loss, because there's been some concern expressed in various amicus briefs as to how this will be applied, is now set forth by the definition of victim in terms of direct and proximate harm. If you look,
so counsel, it's not necessarily loss that is the harm. You're saying that it's an all-encompassing harm is all-encompassing, including loss. Is that what you're saying?
yes, I think that would be a fair interpretation of that.
But here, there was no loss. They didn't pay extra wages, did they?
They did not pay extra wages, but while time may be fungible, work isn't fungible. If I'm taken away and if cities lost the resources of multiple officers, multiple command personnel from their regular job, and then that has to be made up differently or has to be used in a different manner, they've reallocated resources. They've essentially lost that time. They've essentially lost that ability to recover or to use those resources as they'd allocated.
Were there calls that went unanswered? Were there other citizens that did not have police resources as a result of this?
That was not discussed or that was not covered in the restitution hearing. And I would say in this instance, there's something unique about the crimes here. This is abuse of a 911 system or improper use of a 911 system, as well as a false report to an agency. While Marcy's law defines a victim in terms of someone who suffers a direct and proximate harm as a result of the crime, it also entitles people to restitution for injury suffered as a result of the act itself. And if the improper use of a 911 system as an offense is directed towards anyone, it's directed towards the municipality who receives the call and is deprived of their resources.
But if we accept your argument, it's not limited to 911 calls. I mean, it would be any crime the government would be entitled to restitution for. Under kind of the definition you propose, correct?
And no, I don't think it'd be for anything, Your Honor. I think there's a check on this. Now,
well, what's the check then? Explain from the definition you propose how you get there.
It's from the direct and proximate harm. We use the concept of direct and proximate harm in court.
Right, but isn't, you're saying the direct and proximate harm here is that the city had to expend resources as a result of his crimes. Isn't that the case in any crime?
Oh, well, I don't know that it's in the case of any crime. And I think that the question in this is,
well, why is it different? I mean, what makes this different then?
Well, in looking at a direct and proximate harm, you have to look at whether, I'm looking here for the phrase that I'd like to make sure I'm quoting from that. An act or omission which is within the natural and continuous sequence of events directly produces the injury and without which the injury would not have occurred.
Well, isn't that the case of any crime then? Doesn't any crime naturally lead to an investigation of that, which leads to the expenditure of taxpayer dollars?
I think that that's a factual determination to be made on a case-by-case basis.
So what would be the defining fact then?
I think you have to look and see how approximate cause applies in each particular.
Well, you're just saying the same words over and over again, though. Proximate cause. Why wouldn't the proximate cause of any investigation be the crime?
Well, it has to be an act or a sequence of acts without which the injury would not have occurred.
Right. Again, and why wouldn't the proximate cause of any investigation be the crime that led to that investigation?
I think that there are resources that are normally allocated towards, say, patrolling or towards investigation. But when outside or exceptional resources are brought in, that creates its own particular.
So proximate turns on whether it's exceptional. Is that?
I think
if there's a lot of investigation, that makes it a proximate cause.
I think proximate turns on whether it was an event without which the injury would have occurred. I think it would be more clear in this instance if there had been overtime costs. It would be more clear in this case if certain other special services had to be incorporated. In this instance, it's particularly murky with regard to the patrolmen who are already on call and who are already responding. But in this case, it's the additional resources that were expended that were.
So the test, it's an overtime test if only if you have additional police officers who aren't on duty, that's approximate cause?
Not an overtime test. It would be whether the injury would have occurred without the act.
And again, I still don't see from that how we write a rule that would apply to other cases. But
I think the rule would be, Your Honor, that a municipality can qualify as a victim when it's directly and proximately harmed. Now, there may be a determination which needs to be made, as you know, on a case-by-case basis or as the law develops, as to when that injury occurs and when it occurred or wouldn't have occurred but for that act. I mean, yes, there are resources allocated to investigation and police work, which are there on a day-to-day basis, but there are exceptional amounts and times when there's exceptional effort expended.
do you think that when the average voter went to vote on this amendment 2 or 3 years ago, they thought they were creating rights for municipalities?
I think that a person has always included artificial entities created by law and recognized.
So, I mean, do you think that's the way the average voter who went to vote on this amendment would have understood this amendment?
I think we attribute knowledge of the law to the voter, and I think that we have to assume that under the law.
So is the question whether or not the municipality can be a victim, or whether or not what happened here created harm?
Your Honor, I think it's the first one, whether a municipality can be a victim.
Well, didn't you just say that you know the law's pretty clear? Is that your position? The law's clear that artificial or you know non-human entities can be victims. Is that universal?
I think under the law as written for Ohio, I can't say universally. I've not seen the issue addressed for other states that have adopted Marcy's law. I know that when the term person is not defined, the U.S. Supreme Court in Cook versus Chandler noted that it commonly includes artificial entities and specifically noted that that includes municipal corporation. As to your first question, I believe the issue accepted to review by the court was whether a municipality can be a victim when it suffers an injury as a direct and proximate result.
Well, okay, so you're a victim whether there's an injury or not. If you're involved in some way, I mean, Marcy's law is pretty expansive. And whether or not you can quantify your harm or your damage or your loss, you still can be considered a victim. Is that what you're saying?
I think when the act is directly against you, yes, you are considered a victim. Now, you still have to, a restitution is a make whole remedy. So there has to be something for which you're made whole. So it's not just, oh, you're a victim, and so now you're entitled to something. You have to be made whole. But as you said, the issue isn't in this instance whether it was an economic loss. That was the second proposition of law, which actually wasn't accepted for review in this court, but rather it was the first proposition of law, which whether a municipality can be a victim of crime. So, Your Honor, in this case, I think we find that the direct and proximate requirement acts as a check on any concerns of the amicus briefs with regard to the application of the law. And I think that the U.S. Supreme Court has pretty clearly indicated that since 1863, a person is including a municipal corporation. We think that a municipal corporation should be considered a victim entitled to restitution whenever it suffers harm as a direct and proximate cause or direct and proximate result of a crime, or as well when a crime is directly committed against it. We'd ask that you reverse the Court of Appeals and remand the case for consideration inconsistent with this court's opinion. I'd like to save the remainder of my time.
Thank you. Mr. Clark.
Chief Justice O'Connor, may it please the court. Centerville is asking for restitution to pay for the hourly wages of government employees. This is a budget subsidy from one of its residents for costs that would have occurred on April 3rd, 2018, even if Mr. Knabb never called 911. But this case is about more than restitution. Other rights, unremarked upon by Centerville, are at stake for victims. If the constitutional definition of victim is broad enough to include municipalities, then Article 1, Section 10A of the Ohio Constitution would give other rights to city governments from the moment a complaint is filed. These additional rights may include the ability to fight otherwise routine discovery requests, except as authorized by the state constitution, leading cities to fight over whether they need to comply with Criminal Rule 16. Speedy trial rights for municipalities could harm a plea bargaining process that is preferred by people who are actually victimized.
Counsel, let me ask it this way. If a perpetrator bombed a city building, can the city recover in restitution for the cost of that building?
Under existing statutory and case law, yes. There's no need for Marcy's law to permit that.
But aren't they, the city would be a victim in that case, correct?
They would be under statutory and case law, but under Marcy's law, I don't believe they would.
You mean they weren't directly harmed by the blowing up of their building?
They were directly harmed, but they are not a person for the sense of the definition of victim in Marcy's law. And there's good policy reasons, of course, to allow restitution in those circumstances, but we don't need Marcy's law to guarantee that. And we know that municipalities are not victims under Marcy's law from the text of the constitutional amendment, from its own internal structure, and from the relationship between people and municipal corporations in the broader structure of the Ohio Constitution. So this court should hold that Article 1, Section 10A of the Ohio Constitution does not give municipalities any procedural or substantive rights.
Counsel, if the city had to, in this circumstance, bring in more staff, more police, brought in the SWAT team, that were off duty and they're now getting overtime, and there's equipment and there, et cetera. Would that be covered under the other statutes that you're talking about rather than Marcy's law?
Not currently, but that's still, and I want to emphasize, this does not leave the city's hands tied, because defining a city, a municipality, as a victim under Marcy's law starts to walk into the constitutional thicket that Justice DeWine was beginning to draw context around with the questions he asked earlier. And excluding municipalities from the definition of victim allows the debate, the policy debate, about when city governments are entitled to criminal restitution to flow through traditional democratic channels. And the
right now you're saying additional expenses that are incurred as a result of any kind of criminal activity. I mean, how far would this go? You're bringing in people and doing, paying them overtime, et cetera. That's not recoverable right now, just because that's the business of the police department.
Well, there are crimes for which it would be recoverable. And the fact, for example, the pattern of corrupt activities statute allows for restitution for investigative expenses out of a recognition that investigating that kind of crime can be very expensive. And what that shows us is that the General Assembly is more than able to carve out situations in which municipal restitution is appropriate. And we should leave that question to the General Assembly. Defining victim as including municipalities for overtime expenses becomes really thorny as a factual matter, because some expenditure of municipal expenses or municipal resources is discretionary. How a city responds to a crime plays a role in how expenses are incurred. When we're looking at those fine lines, we should leave it to the General Assembly to draw those fine lines, and we can, because Marcy's law does not compel the outcome that is sought by the city. I want to go to the text of Marcy's law now and speak directly to the Chandler presumption that the city referenced. The Chandler presumption that municipalities are people does not apply here for a couple reasons. The Chandler court was clear that the presumption is just a presumption that can be rebutted. It is for three reasons: the history of municipal corporations in Ohio, the competing State versus Carswell presumption that this court has for how to interpret fruits of direct democracy and the proponent language in that was used to support the Marsy's Law campaign. So first, the Chandler presumption is based on case law from the early 19th century, including Amity and Cowles. And the history of municipal corporations in Ohio shows that municipalities today have broader governmental power than municipal corporations did in the 19th century when that presumption was developed. And that's because of Article 18 of our Constitution, which is not cited once in the state's brief. Article 18 gives municipalities home rule rights, and it was adopted in 1912. Amity and Cowles, which are the two cases that undergird the presumption in Chandler, were decided long before 1912 and have not been cited in Ohio since 1912 for the proposition that the city seeks to argue. This is because the broad definition of municipal corporations as understood in the 19th century does not apply to municipal corporations as they are understood in Ohio. And to answer the question of whether municipalities are people for the purpose of Marsy's Law, we need to look to State versus Carswell. State versus Carswell says that there's a presumption that the revised code supplies definitions of general terms in an initiative. So we look to revised code section 1.59, which defines person as an individual, corporation, business trust, estate, trust, partnership, and association. But just because the word corporation is in that general definition doesn't mean municipal corporations are. I'm sorry, Justice Fisher, did you have a question?
I understand your argument on that. I was going to refer you to Article 1, Section 16 of the Constitution. I look at the Constitution for the definition. It says all courts shall be open and every person for an injury done, they have an opportunity to go to court. Don't municipal corporations fit that definition of person?
No, because we looked at Article 18 to define municipal corporations if we're looking in a constitutional sense. And the only time that person is referenced within Article 18 is to suggest that municipalities may contract with people and may do other things with people.
So Article 1, Section 16, the municipal corporations can't go into court and sue?
Municipal corporations can go into court and sue. But if we look at Article 1 broadly, we're looking at rights that refer to individuals. The powers that the Constitution defines our municipalities not in terms of rights they have against the government, but in terms of positive power that they have to exercise as governments. And throughout the revised code, and we presume that these statutes are constitutional, there are specific narrower definitions of person for specific chapters that include municipal corporations. For example, revised code 101.70 says that for the purposes of lobbying the General Assembly, municipal corporations are people. There would be no need to include that additional language in revised code 101.70 if in fact the general definition of person included municipal corporations. Further, we look to statutes in the revised, there are areas of the revised code where we moved from a common law regulatory scheme to a statutory regulatory scheme. Two examples are revised code 3734.10 and 6110.08, talking about riparian rights. And in those cases, there's a private right of action carved out for both people and municipal corporations. We would not need to carve out that private right of action for both people and municipal corporations if our law understood municipal corporations to be people. Finally, I think that we need to look to the proponent statements in support of Marsy's Law, because those proponent statements are consistent with the Carswell presumption that municipalities are not people. The proponent statements spoke in terms of individuals and families and giving victims dignity interest. And while it's absolutely true that Marsy's Law was broadly supported by the Ohio public, it's less than clear that the broad Ohio public would have supported including municipalities in the definition of person, especially because doing so, as amici argued, could put municipalities into direct competition over restitution resources with those who we more commonly think of as victims, including domestic violence victims and human trafficking victims. So it's important, I think, to look at those statements because person is a contested term. And when we're interpreting the fruits of direct democracy, there's no legislative debate or deliberation about what those terms mean. It's an up or down vote. And the way to ensure democratic legitimacy of these fruits of direct democracy is to define those terms narrowly and let the debates outside of those terms be taken care of by the legislative process.
Counsel, does Marcy's law have language in that constitutional provision that says this trumps all other statutes, that would be contrary to what is the contents of Marcy's law?
Yes, it does aggregate sections.
So if they redefine victim in the Constitution, does that not take care of the argument that you're making that in some statutes, the municipal corporation is added specifically, which you say is a conscious effort by the legislature to do so, whereas when person is just referred to in other sections, it only means an individual, not a municipal corporation. Doesn't the blanket language of Marcy do away with those distinctions you're attempting to make? Because they would be contrary to the definition of victim in Marcy's law.
I'm sorry, I didn't mean to interrupt your question, Chief.
Okay.
No, it would not in any sense, because my arguments go to how the definition of victim in Marcy's law is defined. So my argument is that person, as part of the definition of Marcy's law, is not capacious enough to include municipal corporations. And to the extent that municipal corporations would seek restitution, the General Assembly can always pass additional laws that don't conflict with Marcy's law, expanding municipal restitution. Further, Marcy's law would not abrogate the current case law that provides for municipalities to get restitution in some circumstances, because that case law and that statute in that context does not conflict with Marcy's law.
Counsel, do you believe that the city here, that the activity of your client was against the city, the false 911 call and what he was convicted of, that was done against the municipality, correct?
Yes, I think calling 911 does expect the municipality to expend resources, but it didn't harm the city here
but that's not the, I mean, I guess you don't have to have harm in order to be a victim.
True, but to the extent that there's going to be divisions about municipalities being able to recover in proprietary context, but not governmental context, looking to the harm is necessary to define when a city might be a victim, if there's room in Marcy's law for cities to be victims. And if that's the nuance that the court is going to walk down in this case, this is the wrong case to do so, because there was no harm. And there will be a situation in which the issue is more squarely presented. So this court should consider dismissing this appeal as improvidently accepted, should we start to look into more nuance about when municipalities may be victims and when they may not. One last point I want to make: the broader structure of the Ohio Constitution supports this argument, because there's an entire section of the Ohio Constitution devoted to municipalities, what they may do, what their rights are as against the state government. And Marcy's law is simply not referenced, not talked about, not discussed at all anywhere in Article 18. Marcy's law protects crime victims, not the government. Should the city seek a broader right to restitution, it should take this request to the General Assembly. I ask this court to affirm the second district.
Well, which is it? You want us to IA it or you want us to affirm it?
I would be happy with either. I think that to the extent that the court wants to address the question here, the court should affirm the second district. To the extent that this case does not squarely address some of the nuances that were discussed in oral argument, IANA is appropriate, and waiting for a more squarely presented case would be appropriate.
Thank you. Counsel, you have a little more than a minute left. You'll have to turn your mic on.
Thank you, Your Honor. And looking or thinking about Mr. Clark's comments, I think that it's a question of whether you're putting the cart before the horse. I think, as you noted, that Marcy's law supersedes the existing law. It supersedes the prior application finding limitations on a government's right to recover restitution. Instead, Marcy's law just simply defines who's entitled to restitution in terms of proximate harm or in terms of who the crime is committed against. Now, if the legislature wishes to change that, there are certain rights which a municipality doesn't have with regard to due process against its enacting or enabling state, the state that creates it. But that's up for the legislature to do if it finds that the law is being improperly applied. So the legislature could provide a remedy to any concerns expressed by the amicus briefs, but instead that should be addressed by the legislation prospectively, and it shouldn't be applied on the front end in an attempt to essentially rewrite the statute. And then looking at this, I think if you're looking at the Cook decision, that Cook decision is from 2003, Cook v. Chandler. It's not something long ago or only dealing with something from a time which doesn't exist anymore. It's within the last decade or so. So in you looking at that, I think it's clear that a municipality can be a person under Ohio's Constitution, and that Marcy's law, as written, provides the municipality a right to be a victim. The issue of when exactly it experiences harm in that isn't directly before the court today, but I think it's entitled to restitution whenever it experiences harm as a direct and proxy result of a criminal act. So we would ask that the court reverse the Second District Court of Appeals, issue a proposition of law or issue a finding of law consistent with the city's proposition, and remand it to the Court of Appeals for further review.
Thank you. Thank you. We'll take the matter under advisement. You'll be notified of our decision. Our second case this morning is 2019-923 In Re AM for the appellant, Ms. Doherty. You'll have to unmute your microphone. Ms. Doherty, unmute. We can't hear you. There you go.
Thank you.
Proceed.
Chief Justice O'Connor, may it please the court, I'm Cynthia Doherty, counsel for Brianna Dickerson, mother of AM. I would like to reserve 3 minutes of my time for rebuttal. In parent termination cases, Ohio law requires the juvenile court to consider all relevant factors, including the mandatory best interest factors contained in Revised Code 2151-414 D1A through E, before terminating parental rights as required under Revised Code 2151-414 B. We are here today to determine what it means to consider and whether consideration requires some written discussion as to what facts and evidence the court used when considering each factor. In order to properly consider all relevant factors and each of the best interest factors, a written discussion is necessary. In this case, the trial court failed to provide such discussion on an important factor pertaining to the relationship between AM and mother as required by 414 D1A.
So Ms. Doherty, in this case, there was a magistrate's report, and then your client had an opportunity to file objections. Did your client object and say that the best interest factor wasn't discussed?
I believe so, yes, her trial attorney.
So they made that objection.
I believe so, yes.
Are you sure?
I'm not sure.
What if she didn't? What would that mean?
Well, I think if we look at the independent review of the judge, it is the same situation where there isn't any reference as to the evidence that was used to make those determinations. It looks like a page and a half. So I would say, given that the judge's review is lacking in that sense as well, that we could proceed this way.
Well, I mean, isn't the point of objections to a magistrate's report is that if there's a problem, let's point it out to the judge and they can fix it now. Look at that factor rather than having to deal with it on appeal.
Well, it's the same issue that I'm raising here about the judge's review, that it was lacking in the analysis as well. And I think we may be able to look also to what the court is currently doing. The court in Hamilton County is actually making these changes and putting in these best interest discussions.
Counsel, on 2151.414D, it says the court, quote, shall consider, close quote. But in 2151.419B1 says the court, quote, shall briefly describe in the findings of fact, close quote. Or in 2151.28L, the court, quote, shall include in findings of fact and conclusions law specific findings, close quote. If the legislature wanted to say findings must be written down, couldn't it have just said it?
Yes, I think in that sense you're correct. However, it's even more confusing to everyone when there is some discussion in a few of those factors and no discussion in other factors within those same mandatory factors. How do we know that the missing considerations were actually looked at or considered? So in this case, we have 3 factors with some writing or discussion, and we have 2 that have nothing. So the court makes it a little more confusing if you don't have based on the way the magistrate was writing her decision. It would seem that it's either one or the other, but to assume that she found nothing in the relationship between mother and AM when 414D1A actually is asking for what the interaction and interrelationship between parents and children are, then I think that there's evidence in the record and testimony at trial that speaks to that, directly speaks to that relationship, and we're absent that consideration. So how we can come to a determination that all those factors were considered, how do we know they were considered?
Counsel, had the magistrate recognized the bond between AM and her mother, would that have made a difference here?
I believe it would, Your Honor. I think that mother
In light of the other findings, you think that that would have trumped the other findings?
I think that the courts has determined that no one factor gets more weight than the others. However, we have 2 that are missing in analysis and facts to that law. And I think it would make a difference if we go back and look at that. I think the court has said that the parent-child bond is extremely important.
granted, but with all the other findings and the failures of your client, you know, with the reunification and, you know, what she was mandated to do, you think the fact that the mother and child have a strong bond would have countered all of the other three factors that weighed in favor of the judge's decision?
I do, because one of the factors which I did not raise was that there was more time. She was not in the custody 12 to 22 months, but the other issues are that mother.
Are we talking, is that before us, what you're talking about
No.
now?
That I did not raise.
Okay, so we're not considering that. So we're just considering what you're saying is the child enjoyed being in the mother's company.
Yes, but in spite of all of mother's obstacles, in spite of everything that was thrown in front of her, and in spite of her history in the past and the fact that she was a minor mother struggling by being in the custody of the agency at the time as well, in spite of all that, mother made a bond with the baby. Mother continued to visit, and the only reason her visits were ever canceled had to do with when she emancipated, her Medicaid stopped and she had to reinstate that. And then she missed visits due to her work schedule and they were reinstated by the agency. So there was never any issue with mother's bond with the baby, with AM. If you look at the 4D1A, it does consider the interrelationship between AM and mother. And there was testimony in this record about that relationship. But the other part that's missing is the 414D1E, which considers whether any of the factors in 414E 7 through 11 apply as the relationship to the parents and the child. It differs from the actual interaction and interrelationship between the parent and the child as is considered in D1A. So that other factor, that D1E, this is where the magistrate applied facts to that law that don't even apply to anything in that law. So applying 7 through 11, which speaks about is there any plea of guilty under certain enumerated offenses, whether the parents withheld medical food or care, whether the child was placed at risk due to drug or alcohol abuse, whether the child was abandoned. The magistrate didn't speak to that in those issues. She spoke to visiting issues, which I already touched on, and an altercation between mother and father in 2017. So we still don't know if the magistrate actually considered E, factor of D1E. The actual writing that she has in section E would indicate that she did not consider that. It would support her not considering it. I mean, this is about a mother who at the time of AM's birth was 16 years old, herself had been in care, in the agency's care since the age of 13. Mother was very young and truly had a difficult life, as you can see in the facts section of Mother's brief, both prior to and while in the care. Mother was placed in several foster homes and a residential facility. Mother reported being raped by a foster father when she was 15 years old, and the rape was such a traumatic event. The court should have given mother more time. When mother was 16, she began being involved with AM's father and gave birth on November 10th of 2015. Mother did complete a residential program. She began her permanent plan living arrangement, and she also had drug screens and parenting classes. So mother did guys and girls off drugs. She reached out and did some programs on her own. After she left residential treatment, it took the agency 5 months to get her follow-up care. All throughout the case, the agency filed their reports to the magistrate months late. One of them was even 5 months late. And Mother, as a minor, had a GAL appointed, and that GAL never filed one report as to what's in the best interest of minor mother at the time. So in spite of all these obstacles moved around, not only prior to coming into care, while in care, mother still maintained a bond with this baby. I think to look at the due process requirements and the consideration there, we have to look at the interest of the parent and her liberty right to raise her own child, the risk of an error being presented by a lack of a written discussion when considering those best interest factors, and the cost and the burden on the state to add this requirement to have a discussion, and the interest of the government in the effective adjudication. And if there's no other questions, I would like to save the remainder of the time.
I do have one question. You're advocating for a rule that says in every case, there has to be an explicit discussion of every best interest factor. What about a case where, a couple of the factors really aren't at issue and the case really turns on, a very important factor, and the magistrate writes about that, analyzes that, and doesn't talk about something that's not important. It's not an issue.
I think that the consideration should equal a discussion. I mean, that is how we do law.
That's not really how we do law, right? I mean, generally we do law we focus on what's important. We have statutes all the time that's, there may be factors that don't matter. So you focus on the factors that matter. Why shouldn't that be the rule?
Because we don't have a way to know if the magistrate considered all those factors, which is required by the law. And I think that if we consider this parent termination in the way the court has handed down that it's a civil death penalty for parents, then in those death penalty cases in the sentencing stage of it, at least there is factors that are considered, and the statute uses the word consider, to where it also equals a writing, a separate writing and opinion about what was considered in those mitigating factors. So
Counsel, was there any dispute that the child, AM and Brianna had a good relationship?
I don't believe so.
Then what's the controversy here? To Justice DeWine's point, that's a given.
I'm sorry, I'm not understanding what you're asking.
If there's no dispute that Brianna and the mother or the child had a bond, what's the dispute that, why would that be a factor that would have to be expounded upon by the magistrate?
Because that's the first factor that the legislature put in there as part of the best interest analysis. When they determine the best interest of the child, that's one in there. And the juvenile courts are courts of best interest. So that is the main focus, as in Cunningham, that it is, those best interest factors are in both analysis and both those pathways to go to permanent custody.
Is the problem here that the magistrate didn't discuss a factor, or is the real problem here is that if you read this decision, it just doesn't seem like there's any real weighing or thinking about best interest at all? I mean, it's almost devoid of analysis. I mean, isn't that what we should worry about? Not whether or not there is a checklist of factors that were mentioned?
I think, yes, you're right that it does seem like it's void, but I think to just assume that there is nothing there and that the magistrate considered it because it's absent some consideration or some discussion about the consideration is not the way to go. I mean, wouldn't it be better as a policy if we could say to parents, here is what you did wrong, even if they are wrong. And if it's not, there's a way to challenge what the magistrate considered if we're missing a discussion about the evidence, as in this case. we're missing that critical piece in A1. I'm sorry, 1A. And if there's no other questions, I believe I'm over time.
All right. We have Mr. Varney first.
Yes, Your Honor. Good morning, Your Honors, and Chief Justice O'Connor, may it please the court. Nicholas Varney, representing Hamilton County Jobs and Family Services. Your Honor, in the present case at bar, we contend that the plain language of the statutory section at issue here, 2151D, is unambiguous, and as such, there's no need for a court to interpret the language of that statutory section, and the court must apply the statute as it's written. Here, 2151D states in pertinent part that the court shall consider all relevant factors, including but not limited to, and then it goes on to list the best interest factors that the court need to consider. Here, I'm sorry.
If the language is that the trial court shall consider, how is an appellate court, in order to provide meaningful review, if there's no discussion of the facts in the opinion, is it enough for the trial court to just simply repeat that statutory language that it did consider it, and appellate courts have to assume that they did if they state that?
Certainly, Justice Donnelly, I think maybe a more robust discussion of how the court considered and used the facts and evidence and in the record to arrive at their decision would be helpful. And in fact, the First District in its majority decision said that it would strongly urge the juvenile court to do more of a discussion, but it could find no fault with the court's ultimate decision here, given that the facts and evidence and in the record and that were presented at trial supported the finding that the magistrate ultimately made. So,
right. Well, given the Supreme Court's part of our duties to provide guidance to the lower courts, wouldn't it benefit both sides, including your side, to require at least, maybe not address any checklists that are items that are irrelevant, but at least require trial courts to provide some discussion of what they found credible, what they weighed, persuasive? Wouldn't that help everybody involved?
Yeah, Justice Donnelly, I completely agree with you on that. And I think to Ms. Doherty's point, I think courts are starting to do that now. I certainly wouldn't present this magistrate's decision to the court and say this is the best decision that anyone has ever seen. But I would agree with the First District that when taken in totality, when reading the entire decision, which the juvenile court did and the First District did in its review, ultimately the findings that were made and the decision that the magistrate made was amply supported by the evidence and by the record. So I do not disagree whatsoever. I think courts can always do the best job that they're able to in giving parents and the agency and other litigants as much information as they possibly can should something be appealed or reviewed by a judge. So I certainly don't disagree. But given that, I would, again, just state that the First District, while it did indicate to the juvenile court that it would be best practice to discuss more, it couldn't find any fault with the juvenile court's ultimate findings, and that's why they affirmed.
Mr. Varney, I appreciate your candor about the failings in the magistrate's report. I mean, really what happened here was, and if you look at the magistrate's report, there's really no analysis. And the Court of Appeals went back and did the analysis on its own. It went through and said, okay, here's the record, here's what we have, and this supports the decision that the magistrate did, and essentially wrote the report that the magistrate should have written. Which is fine in a way, but what concerns me there is, in that situation, how does the litigant have a chance to object to the Court of Appeals findings, right? If the magistrate made findings, the litigant could object. But if it's the Court of Appeals that's doing that, as happened here, how does the litigant have a chance to object and say, no, these findings aren't correct that you're making?
Well, and I believe, Justice DeWine, that that's why we're in front of this honorable court this morning, just for that reason. Certainly, having the first district do essentially the work of the magistrate in juvenile court kind of makes the appeal process a little bit more difficult. And like I said, I am hopeful, as I believe all of my colleagues in juvenile court are, that the decisions that are being produced in juvenile court today are much more robust than the one that's before the court this morning. That brought us to this point. So I think that there is some serious concern, Justice Wine, that if decisions like this were to be more common, or the first district were essentially playing cleanup for the magistrate's decision, that it would prevent litigants with it to have a cognizable chance at a meaningful appeal. But again, I do think that this case, again, while the decision is not the most robust, the court got this right. I think that the court found that the best interest of AM was served by placing the child into permanent custody. And I think, again, a point that I made earlier that struck me as I worked on this case was that the record has to be taken as a whole in these cases. Dependency cases span months and years, and there's a litany of evidence in the court's record that it must consider when making a decision at the end of trial when posed with a motion for permanent custody. And that includes status update reports, review reports, reports by guardians ad litem, reports by Jobs and Family Services. And I believe that the magistrate considered all of that information when making this decision.
Counsel, if you look at the Court of Appeals opinion, paragraphs 20 through, I think it's 25 or so, there's a recitation of the findings of the magistrate and then affirmed by the Court of Appeals. And there's a whole litany of shortcomings. The mother's failure to meet all of the, I guess, reunification plan milestones that, and there's no dispute that this was true, and it came out at trial. She uses marijuana. She doesn't think that she needs to stop using marijuana. You know, she's not participating in the programs that were laid out for her, et cetera. I mean, it's all laid out there in the 4 or 5 paragraphs there. Then you balance that against the fact that there is no, I guess, in the appellant's view, no appropriate emphasis on a factor such as the child and the mother get along well together, that there's a bond there. And my question, you know, previously asked, would that have trumped all this? Would that have made a difference? Is that, you know, so significant that the magistrate, the trial court, and the Court of Appeals should say, well, clearly that's going to, you know, change and make up for all the, you know, other findings that are in these paragraphs?
Chief Justice, I don't think that specific finding of a bond between AM and her mother would have overridden the other considerations that the court took into account that you just listed. You know, I've practiced juvenile law and dependency law my entire legal career, and I was previously a guardian ad litem. Excuse me, and I can say that most children, if not all children, have a bond with their parent. And I believe that absent really extreme circumstances, that evidence is going to be presented at trial. Of course, the child had a bond with her parent. However, the child was very young at the time of this trial. And, you know, any young child who is being cared for by their parent is going to enjoy that time. But as you indicated, there was a mountain of other factors that weighed against mother being able to get a remand of this child into her custody and care for this child. I think that the evidence weighs incredibly heavily towards the fact that mother was not an appropriate parent, regardless of whether she had a bond. So I don't find that fact to be dispositive at all, Your Honor.
But counsel, aren't we required to just speculate on that fact? Wouldn't it have been better for the magistrate to say this evidence was presented and I found it credible or not credible? But regardless, the way it comes out in the end, it doesn't trump. And it had that discussion. Yeah, that would be better for both sides, right?
Certainly, Justice Donnelly, I completely agree. And most decisions that we look for at the end of permanent custody trials would have that consideration and that discussion in them. So I can't argue with your point there whatsoever. So just to wrap up, because I think I only have a few moments left, touching on due process, in the agency's opinion, mother's due process rights were not violated here in this case. She was afforded counsel. She was present at the trial. She was served with the pleadings that were filed by the agency. She participated in trial preparation with her attorney. She testified on her own behalf, and she appeared and participated in the trial. So this information that the magistrate, albeit in a disorganized manner, presented in the entry, mother was aware of all of those factors because she was at the trial, and I believe that her due process rights were exercised in that way. And I think with that, I'm out of time. I would like to cede the rest of my time to the guardian ad litem.
Thank you. Is it Ms. Weingartner? You'll have to unmute.
I apologize. Good morning. Chief Justice O'Connor, may it please the court. My name is Celia Klug Weingartner, and I am the attorney guardian ad litem for AM in this case. As AM's attorney guardian ad litem, it is my position, and today we are asking this honorable court to uphold the First District Court of Appeals decision, uphold the decision of the Hamilton County Juvenile Court that grants permanent custody of AM to the Hamilton County Department of Jobs and Family Services. As AM's guardian ad litem, it is my position that permanent custody is in AM's best interest, and it is in AM's best interest that this court apply the statute as it is written and not interpret the statute. I would submit to the court that in this case, as the agency presented, and I completely agree with this, is not the gold standard magistrate's decision here. It is not the gold standard of the way it should be written. I would submit, though, that all of the factors were considered when you take in light the whole record. Appellant relies heavily on the interrelationship factor, bond between mother and child. The agency touched on this a little bit, but I would submit to this court that most parents involved in permanent custody cases have a bond with their children. In most cases, that bond is going to exist. In this particular case, I believe it did, but as previous counsel said, it is not just positive in this case. The best interest factors are not a checklist to go through determining which ways in favor of a parent, which ways in favor of a state needs to be considered as a whole and weighted. In this case, I submit to this court that it was weighted, and it did weigh in favor of permanent custody being granted to the Hamilton County Department of Jobs and Family Services. Would note as well and submit to the court that this is only the second part of the analysis. The best interest factors come after the first finding of facts in the permanent custody statute. And there's no argument, there's nothing being contested that that was not successfully met to grant permanent custody of AM to the Hamilton County Department of Jobs and Family Services. Would also note for this court that this court and no other court in the state of Ohio has ever held that it was necessary for a discussion. We would be asking this court to apply the plain language of the statute, which says consider, as opposed to interpret the law and change it at this point. I would also present to the court that if this court thinks there should be a requirement for discussion, that it should happen through the Ohio legislature as opposed to this honorable court. I would also submit that if the court views the appellant's argument to be persuasive and rules in favor of appellant, that the proper remedy is not a remand of custody. It is not a dismissal. It is not a new trial. It is a review of the entire record in this case and a rewrite of that decision to demonstrate a consideration. As the First District, I believe, has done before in re-KT.
Counsel, do you think it's appropriate for the appellate court to, first let me ask, how does an appellate court review a decision like this by the magistrate and by the juvenile court? And is it then appropriate for the appellate court to actually set forth the analysis?
Your Honor, are you asking if First District should set forth the analysis, or if
First, how does an appellate court review a magistrate's decision or juvenile court's decision saying we've considered all of the statutory factors? Is that statement enough?
Your Honor, my belief there is that you can review the whole record in this case if you were to determine that was the right way, meaning reading the trial transcripts, reviewing the reports that have been submitted. As counsel discussed, there's more to this than just a trial, and take all that evidence in light of the entire record, and from there rewrite a decision showing consideration.
Did you say rewrite a decision?
If that is the remedy that this court saw fit, if they were to rule in favor of appellate.
So doesn't that, if what comes from the trial court, nothing more than what was sent up in this case, or a mere statement that we considered all the factors, the statutory factors, then could the appellate court do the same, consider the factors, and come to a different conclusion?
I believe they could, Your Honor. I mean, that is the purpose, in my opinion, of an appellate court. If they were to review the whole record and think the magistrate made the wrong decision, I believe they could do that.
What's the Court of Appeals standard of review?
At this point, they're looking for error in general, Your Honor. I don't found it.
For legal error and de novo review?
Yes.
There's no there's no discretion on the part of the trial court in how these factors are weighed?
Are you referring to the judge or the magistrate, Your Honor?
Well, if the magistrate conducts the trial or the hearings and the judge, the juvenile court judge, signs off on the magistrate's decision, which ultimately has to happen for there to be a final judgment.
Yes.
Then what comes up to the appellate court, assuming the juvenile court judge did nothing more, what the Court of Appeals does is review what the magistrate decided.
Yes.
Correct?
That is correct.
And so then if the appellate review is, if the appellate court reviews an order that says, upon review of the statutory requirements, we find it's in the child's best interest that permanent custody be awarded to the county, then what happens next? The appellate court should essentially rubber stamp that, or is it up to whoever appeals, the appellant in that case, the parent, to say, well, this decision didn't make sense because there were more factors that weighed against permanent custody? In other words, is it the appellate court that should undergo the analysis as what happened here? Is that the appellate court's job?
I see what you're saying. No, Your Honor, I do not believe that's the appellate court's job. I think that's how we ended up before you in general. I think it is their job, though, to take in light the whole record and make a decision about whether the correct decision at the trial court level was made. And I think they did that here.
But I guess, and these facts probably, are not the best ones, granted. I guess my problem with that is if it's a close call by a weighing of the facts, if it's a close call after appellate court weighs the facts, then one would say you have to affirm the trial court's decision. But, if it's not a close call after weighing those factors, then you'd have the appellate court reversing, I don't want to use the term substituting its judgment, but essentially that's kind of what would happen.
I see what you're saying. In this case, I believe the factors, as previous counsel said, do not weigh in favor of appellant, which led to the uploading. I get what you're saying, where there may be a concern in a closer case. Here, though, I don't think there's any evidence that the trial court erred as a matter of law.
Thank you.
Thank you.
Ms. Doherty? I'm trying to see how much time you have left. I think you've used your time, but you may take a minute.
I just wanted to make it clear on the court that our district did have a case where they, following the two cases in KT in August of last year, 2019, where that first district did reverse and remand with instructions to consider the best interest and discuss them with specificity. So to give the notion that our district, first district, has not looked at this and said we need more. And I think that these best interest factors and the fact that this is considered a civil death penalty, that we do need more. And that court also does that. That was in August of 2019, and that was the case of NRA BK children. My client, of course, what we're doing in the courts now doesn't help my client. I think that if the case could go back, it would be difficult for this to have just a review, because the magistrate that was sitting in this case is no longer on the bench, and being the best trier of facts, able to see the witnesses and discern everything, I think it would have to be a new trial. And with
Thank
that,
you. We'll take the matter under advisement and we'll be notified of our decision.
Thank you, Your Honors.
thank you.
All right, our third case this morning is 2019-1058 in the matter of the complaint of Direct Energy Business LLC versus Duke Energy, Ohio. For the appellant, Ms. Brahma.
Thank you, Madam Chief Justice and Justices of the Court. My name is Elizabeth Brahma with Taft, Stettinius, and Hollister. I'm appearing today on behalf of Duke Energy, and I would like to reserve 3 minutes for rebuttal if I could. This case arises today because the Public Utilities Commission of Ohio made determinations about Duke Energy Ohio activities and potential remedies related to those activities that are within the exclusive jurisdiction of the Federal Energy Regulatory Commission, or FERC, as explicitly recognized by the tariff for the state, which was approved by the State Commission. The background that's pertinent to this matter is laid out in detail in the parties' briefs, so I will not revisit it here. It's important to be clear, however, what activities are and are not at issue. In the arrangement at issue before this court, Direct Energy obtains power from PJM, the Regional Transmission Organization, or RTO. Duke provides services to Direct Energy to facilitate Direct Energy's purchases from PJM, and PJM in turn bills Direct Energy for services under the Federal Open Access Transmission Tariff. Duke's activities were to supply hourly load data in accordance with the Open Access Transmission Tariff, otherwise known as the OAT. This is explicitly recognized in the state tariff. In other words, all of Duke's activities, really the singular activity at issue here, which is to supply hourly load data, is premised on a federal tariff which prescribes both the method in which hourly load data should be supplied, as well as the remedies in the event that there are any questions or issues about the manner in which that data is supplied. Duke's merit brief outlines 4 legal errors in the Commission's April 2019 opinion and order and the June 2019 entry on rehearing. Given the time for oral argument, I intend to focus my argument on 3 key areas: the Commission's lack of subject matter jurisdiction in this area, the conflict between the Commission's conclusions and state law, and where the state tariff and laws require certain findings the Commission neither made nor had jurisdiction to make in any respect. So I'd like to start with the issue that the Commission lacks subject matter jurisdiction to make any determinations about whether or not the Duke Energy's issued or provided adequate service, given that the federal tariff governs this matter. The Public Utilities Commission of Ohio had no jurisdiction.
Before you start that, let me ask you, analytically, do we look at whether there is preemption first, or do we look at whether or not PUCO had subject matter jurisdiction based on the definition of a public utility? Do we have to do those? Do we have to make those inquiries in one order or another?
The issue, the primary issue that I would argue is one of the fact that the commission lacked jurisdiction because of federal preemption. That is the first issue. And if the court finds that the determination of whether the utility or whether, excuse me, Duke Energy provided hourly load data in accordance with the federal tariff is in fact a matter of federal determination, there's no need to make any further determinations about whether the commission had subject matter jurisdiction otherwise, because the sole issue before us today is whether the Duke provided and supplied hourly load data in accordance with the federal tariff as set as the state tariff
Counsel,
recognizes.
aren't we, first concerned on whether Duke, in its capacity in relationship with Direct, occupies the status of a public utility under Ohio law?
That is also an issue before this court. But even if you were to find that Duke was a public utility in some respects, where we have a federal tariff that governs the activities of the utility or of Direct Energy, of Duke, that federal tariff is what ultimately governs how the services are to be provided and whether a remedy is available.
Well, right, because that's when you get to the preemption issue. But let's go back and take a look at the statute and whether or not Duke enjoys the status of an energy, or excuse me, a public utility, which would come under the auspices of PUCO. And if they don't, all right, that's the end of the discussion, I would imagine.
Correct. I agree with that as well, Your Honor. And the issue, I think, there is they're not necessarily directly related, although they are both determinations this court can make. The state statute definition of public utility turns on whether or not Duke is acting as an electric light company or an electric utility in its capacity supplying hourly load data. The definition of the state statute with respect to whether or not Duke was acting as an electric light company speaks to supplying electricity or supplying transmission services. Those are not the activities that Duke was involved in with respect to this matter.
So then that means that they're not a public utility subject to PUCO's jurisdiction.
I would agree with that. And I would also say that with respect to the specific issues that are raised, that Duke has raised in its brief with respect to whether or not the state law precludes exculpatory clauses in tariffs, and also whether the commission has to determine whether Duke provided adequate service. Those only apply to public utilities. And where Duke was not acting as a public utility, there is no bar against an exculpatory clause, nor is there any basis for the commission to find that there was inadequate service in this instance. The reason I wanted to start the issue or my discussion with the federal tariff is because it is straightforward on the face of the commission's orders and on the face of the state tariff. The opinion and order of the commission, as well as the entry on rehearing, both acknowledge that Duke's obligation was to supply hourly load data in accordance with the open access transmission tariff. This federal tariff, notably the state tariff doesn't say that there is some additional state requirement. It is literally a direct referral to the open access transmission tariff. And it is in its entry on rehearing that the commission specifically found that because there was an issue with respect to whether it supplied hourly load data in accordance with the federal tariff, that was inadequate service. That is the state commission treading directly in an area that is governed by a federal tariff and is preempted by FERC's jurisdiction in this
What,
area.
what kind of, are you saying this is conflict preemption, or what kind of preemption are you arguing?
This isn't a preemption in the sense that not so much that there is a conflict, because it does say in accordance with the open access transmission tariff, but the case law cited by Duke in its merit brief, it gives several examples. The California XRL Lockyer case, the AEP case indicate that where FERC has jurisdiction over a matter, and not just the rate itself, but the process and the remedy, that is FERC's exclusive jurisdiction, and the state is not to either infringe on that area or graft additional remedies.
Well, since some of those cases have been decided, the U.S. Supreme Court has issued the Virginia uranium case, which seems to kind of move the ball a little bit on preemption. And I think what the court says is there must be you must point to a statute that displaces or conflicts with state law. So what is the conflict here, or what is the direct displacement?
The direct displacement is set forth in the state tariff itself and in the federal tariff, which acts like a law according to a number of provisions of both United States District or Circuit Courts, as well as United States Supreme Court. In this case, we have a state tariff that explicitly acknowledges that whether or not Duke was supplying hourly load data properly is to be in accordance with the open access transmission tariff. There's really no question.
That doesn't seem like a conflict then.
It
doesn't seem like that displaces any federal law. There's no conflict between the state and the federal there.
There is, because the only question is whether or not the federal tariff is whether Duke acted in accordance with the federal tariff. And the case law at the Supreme Court and at the Circuit Courts is the tariff is like a law. And so where the state court does not have jurisdiction to determine whether Duke acted in accordance with a federal tariff, FERC has that exclusive jurisdiction. And again, not just with respect to the supplying of the hourly load data, but the overall scheme that includes the remedy in the event there's an issue with how the data is provided. And those provisions of the PJM tariff are attached and referenced in Duke's supplement to its merit brief. I think it's worth pointing out too, because the commission has argued and Direct Energy has argued that the state commission has authority here because the state commission has authority over the tariffs that it approves. And we're not arguing that in general that's correct. Certainly the state does have authority over public utilities and also those provisions of the state tariff or of the service that are governed by the state tariff. But here, where the state tariff explicitly references the federal tariff, that issue then becomes one of federal jurisdiction and one of federal preemption. As a result, the issue here was not just that whether or not the Duke initially provided adequate or inadequate service. It is what is the remedy if there was something that was done that was not in accordance with the federal tariff. The several FERC cases that are cited in Duke's merit brief, including GDF Suez, the New York State Electric and Three Phases cases, all make it very clear that when there's an issue like the issue raised in this case, FERC has exclusive jurisdiction for the purpose of determining the remedy, for establishing a final
Here did
process.
the resettlement process, is that something that was provided for in the OAT, or was that something that came from someplace else?
The resettlement processes A and B are part of the OAT. There's a resettlement process C that's a more voluntary process that Duke also pursued. And we know that the resettlement process worked in part because Duke was reimbursed for certain months. It was not totally reimbursed, in part because the resettlement process has a very explicit intent of achieving finality. Sometimes that will be finality to the benefit of an entity like Direct Energy, and sometimes it won't be. But the FERC tariff and the OAT prizes finality and certainty of bills, and that is within FERC's jurisdiction to approve and to set those kinds of policies, even if the state ultimately disagrees and thinks there should be additional remedies. It's important to be clear here, though, too, that even if the PUCO had jurisdiction to interpret the federal tariff, which of course Duke argues it did not. PUCO made no such determinations in its order. We see nothing in the order that speaks to what is actually in the OAT, what provisions govern, what provisions were or were not complied with, what remedies might have been available under the OAT. And as a result, there's no fact or finding in the commission's determinations that would support its determination that Duke did not comply with the OAT, did not supply hourly load data in accordance with the OAT, and therefore provided inadequate service. Earlier, I touched on the issue, and I believe my time is up for until rebuttal.
Thank you.
Is that correct?
You're into your rebuttal time. You're correct.
Yes. All right. Thank you. I'd like to reserve my remaining 2 minutes.
All righty. First up, we have Ms. Blair.
Yes, thank you, Your Honor. May it please the court. I would like to reserve 3 minutes or the remainder of my time for intervening Appellee's counsel, Mark Witt, to argue. Duke dropped the ball in this case. Duke failed to perform a duty that it owed its customer, Direct Energy. Duke was obligated under Ohio law 490522 to provide adequate metering services. It did not. Duke itself filed the tariff before the Ohio Public Utilities Commission. It asked for approval to provide meter data management services, the issue of this appeal. Duke, as a utility provider, is the only entity that can provide that service. Direct can go to no one else besides Duke. The facts clearly show that Duke made a mistake for 7 months in a row. SunCoke was a customer of Duke's. It produced and used electricity. When they took generation and distribution from Duke, the bills were manually calculated by Duke, and they were correct up until January of 2013.
Does federal law govern what happens if there's a mistake made in billing?
Well, that's what happened here. There are the two settlement processes. Settlement B can go back 60 days. And that's what happened here is they went back 60 days, but that did not take.
Why shouldn't we say, okay, the federal laws establish this procedure to resettle if there's a mistake? Federal law places an interest in finality. For PUCO to do something different would conflict with that process.
I don't think that there's a conflict because what was before the PUCO was the 490522 adequate services. This is a metering service. Duke owns the meters. Direct can go to no one else. Duke filed that tariff with the Ohio Commission. The Ohio Commission provided that. The Ohio Commission did not speak to the resettlement process whatsoever. The Ohio Commission did not interpret the oath.
But isn't this just a way around the resettlement process here?
I don't know what Direct will do with the opinion that is issued in this case, but the PUCO has a duty because it had the tariff filed before it by Duke, and it was asked with this under the complaint statute 490526, was this inadequate service according to 490522? And as you can see, according to the facts that the commission saw, Duke was able to provide accurate services. However, when Direct became the generation provider in January of 2000 bills, SunCoke's bills were inaccurate.
Is this a public utility service that Duke was providing here?
It is a public utility service. That's why Duke filed this.
How do we know that other than just that they filed the tariff?
It's metering. Metering is part of the distribution system. Also in this tariff, not the subject here, but further down, you will see that Duke has to own the meters, has to maintain the meters, has to make sure that the meters are
was
accurate.
Duke, I mean, the definition says supplying electricity for light, heat, or power purposes. Was it doing that when it provided the service?
It does facilitate the transmission service.
Well, that wasn't the question. What was Duke supplying here? Because that's the definition of electric light company.
Well, yes, and
public utility.
According to that definition, it was Duke's distribution facilities that allowed for delivery to this customer.
Well, was it engaged in the business of supplying electricity for light, heat, or power? It's not. I mean, lots of things allow things to happen, right?
Yes,
But was it engaged in the business of supplying electricity for light, heat, or power here?
yes, metering is an integral part of supplying electricity. So it was by definition performing a Public Utilities Act. It was by definition a public utility. And again, back to the facts of the case, the commission focused on the facts that Duke was able to provide accurate metering data up until the point where generation was provided by direct.
Ms. Barrett,
And
what kinds of things would you say would not be included in that definition of providing electricity? What isn't included? If this, you're saying this is included, they're providing this service, that falls under the PUCO's jurisdiction. So what doesn't include? What isn't there? Clearing trees from lines, for example?
Well, no, that's a utility service because it's part of the distribution lines that has to do with delivering electricity to the end user. And metering is also a very important part of providing electricity to the end user. Off the top of my head, I'm sorry, Your Honor, I can't think of something that's not a regulated service. But then that's what we look at the commission is regulated services, of which metering falls in. And the tariff obligated Duke to provide accurate metering services to PJM, which they clearly did not.
Does it matter though that the complaint was brought by direct and it wasn't providing electricity for direct? And there is this complicated relationship with PJM and with direct energy. Does it matter that it was direct energy that brought the complaint?
Well, direct energy was the proper party to bring this complaint because they're a transmission customer under the tariff of Duke's, according to Duke's supplier tariff filed at the commission. And direct, in fact, notified Duke of this in February of 2013, the second month into the 7-month continued mistake. They were proper to bring this under 490526. This is the complaint statute regarding public utilities. And it is an avenue for a complaint for any rate, fare, or service provided by a public utility, which Duke is. Duke can't escape that for this metering services. And what that tariff provided was that Duke, acting as the designated meter data management for direct, will supply hourly load data to PJM. Duke will provide this in accordance with the open access tariff filed at FERC. The tariff nowhere states that FERC has jurisdiction over this supplier tariff. And in fact, this Ohio tariff obligates Duke to provide accurate load data to PJM, the words of the tariff at the Ohio level.
Ms. Baird, does FERC have any jurisdiction here? Could direct have filed a complaint with FERC instead?
Direct may file, that might be better directed to Mr. Whip, but if it had to do with the resettlement process and compensation, that may be. That was not jurisdictional to the PUCO in this case. Again, the PUCO did not look at the compensation or the market participant part of the OAT. It didn't in any way translate. It didn't look at that tariff nor seek to bring meaning to the OAT settlement process. It simply looked at the metering services according to the tariff and were they inadequate. And though Duke speaks to the OAT tariff, it's over 3,000 pages long, it doesn't pull anything about the metering information from that. And what the commission did is they saw direct as a captive customer. Duke is providing a monopoly service here. The aggravating facts that the commission focused on were the metering services were correct before 2013, but after that, they were highly inaccurate. The meter service provided to state tariff was the sole issue that the commission looked at. It in no way interpreted a federal question and makes no claim that there was no claim that FERC, no claim by Duke, that FERC had a metering provision in the OAT tariff. The record contains sufficient evidence that the commission relied upon in making its finding that Duke provided inadequate metering services. The commission's made no findings nor spoke to OAT that filed at the tariff. I'd like to speak briefly to the exculpatory language that is included in the metering tariff. The commission found that invalid because the Ohio Administrative Code does not allow exculpatory clauses. And when the commission adopted this rule, it was in fact codifying the commission's long-standing policy in the Ohio Supreme Court's case law that doesn't allow a body that provides a monopoly service to use that to use oppressive terms or things like that in their
Did the
tariff.
commission approve this tariff?
The commission did approve this tariff as a whole.
So why would they approve it with the exculpatory language then?
The commission didn't notice the exculpatory language when they
Didn't
approved
notice
the
it?
tariff. It was approved, but they did, when it was called upon to question it, in this case, the facts of it said the exculpatory clause cannot be because of the OAC. And I'd like to point out something else. In the tariff itself, this metering language is in section 14 along with the exculpatory language. However, if you go farther down in the supplier tariff in section 21.4, Duke itself puts language in there that says the supplier tariff and agreement are subject to present and future regulations or orders of any local, state, federal regulators having jurisdiction. So I will argue that in the tariff itself provided by Duke, it claims that will abide by the Ohio Administrative Code, which forbids exculpatory clauses. So I think on two fronts, the exculpatory clause should not be. The commission properly found that that clause was not valid. Our lights went out. And the claim that Duke also makes a claim that it was an inadvertent and isolated incident. This should be dismissed statutorily because that was not brought before the commission. That is in violation of 4903.10. It cannot stand before this court. It was also in violation of 4903.13. The inadvertent and isolated incident was not raised before the commission on rehearing, nor was it raised on the notice of appeal. Furthermore, if this court does choose to look at the facts, they made the isolated incident 7 months in a row, and it was brought to their attention by direct in month 2. That is not isolated. The issue in this case is whether Duke's provision of metering service was inadequate. The commission looked at the facts and determined that the provision of service was inadequate. The decision was properly made, and this court should affirm the decision. Thank you.
Thank you. Mr. Witt? You'll have to unmute your microphone, Mr. Witt.
Chief Justice O'Connor, may it please the court. I'd like to start by addressing a question Justice DeWine had, and that was whether Duke was supplying electricity. The answer is that it was. It was supplying electricity to Suncoke. So this customer was a distribution customer of Duke and an energy supply customer of Direct. The complaint statute 490526 does not limit complaints to customers. The statute says that any person may file a complaint against a public utility. Persons as well as firm, corporation, etc. Direct is a corporation or firm that filed a complaint against Duke, which is a public utility by virtue of supplying electricity to customers. To answer Justice French's question, well, what wouldn't constitute public utility service? And among other examples that come to mind would be, for example, if one of Duke's bucket trucks rear-ended someone on the highway. Although Duke is a public utility, I'm not aware of any tariff provision that Duke has which addresses how it drives its bucket trucks. So that sort of claim would be subject to a court of general jurisdiction, even though Duke is engaged in the business of a public utility. In this case, we're dealing with a service that's expressly governed by Duke's tariff. And this is a tariff that Duke claims is enforceable by Duke, but not against Duke. And that simply doesn't make sense. There are dozens of suppliers in Duke's territory. And the reason this tariff exists is so that all suppliers are treated equally and fairly. And the obligation exists because Duke has a monopoly over its meters. It is the only person that can provide metering data to PJM. And when we look at the PJM tariff, if you look in Duke's supplement, pages 76 through 119, this is the tariff that they draw the court's attention to. That tariff says nothing about the allocation of responsibility or liability between a public utility and an energy supplier. All it provides for are procedures at PJM to reconcile these metering errors. And council has admitted that the order contains no findings about whether Duke complied with the federal tariff. The commission didn't have to go there because we weren't complaining about the time period that was subject to resettlement. Direct filed this complaint because of a time period outside of the PJM resettlement period. So the state jurisdiction here supplements FERC jurisdiction. It's not to the FERC.
Well, isn't that a conflict if federal law says, okay, you have to resettle something within this time period, and for the state to say, no, you don't have to follow those procedures, but you can resell it outside the time period?
Well, I would call attention to the Strategic versus Western Massachusetts Electric Company case. We cited that. I believe it was pages 9 and 10 of our brief. Goes through the preemption analysis, and it goes through and explains why there is no conflict between federal law and other contractual remedies that may exist between the utility and the supplier. Again, FERC's, and I think it's been agreed that the primary—
This isn't really a contractual remedy, is it? I mean, this is part of a state regulation.
Well, it is, although there is a contract between the parties that essentially says the parties agree to follow the PUCO tariff. So the tariff here has elements of both a contract and a statute. Regardless of which is the case, the tariff simply says that Duke will provide this information to PJM. And Duke admits that it didn't do so. What it provided, it may as well have provided nothing. And their claim is that they have no responsibility whatsoever for this obligation voluntarily undertaken, and that although they can require my client to pay various forms of supplier fees, that my client can be kicked out of the state by Duke if we don't comply with Duke's requirements, that Duke can do all of that, but we have zero recourse if Duke doesn't follow its obligations. And again, this is not an area covered by FERC. Justice DeWine, you asked the question, is there a statute that either expressly or by conflict preempts the state tariff? The answer is no. There's been no statute cited, and Duke just says over and over again, well, it's the OATT or the OAT preempts. Well, what language is preemptive? I haven't heard it. And the court ought to ask counsel, point out the specific language in the PJM tariff that preempts the PUCO, and they won't be able to find it. I see my time has expired. Thank you.
Thank you, Mr. Wett. Counsel, you've you have left about 2 minutes.
Thank you, Your Honors. I want to make very clear here that the only issue that is before the court with respect to the applicability of the supplier tariff is the issue of supplying hourly load data. And to counsel's last point, we would point directly to the PJM open access transmission tariff sections 3.6, sections 5.1. These are provisions that speak directly to how hourly load data is to be supplied to in accordance with the OAT. And because the state tariff in this one area with respect to supplying hourly load data explicitly relies on compliance with the OAT, that's where we are in the realm of the Federal Energy Regulatory Commission jurisdiction. And the provision of law that governs that is the supremacy clause of the United States Constitution, and a body of case law around it that makes very clear where FERC's jurisdiction is exclusive with respect to the tariffs that exist under the FERC jurisdiction. I also want to be clear here, there was some discussion about is Duke supplying electricity? Is Duke doing things under state law that make it a public utility? Counsel for the commission said, well, metering itself is a requirement, but so is setting rates. And the issue is not necessarily just whether or not there is an activity that exists that might fall under the question of the state law. There are multiple activities that an entity like Duke undertakes that could fall under state jurisdiction or could fall under federal jurisdiction, depending on the parties involved, the nature of the activity. And in this case, the case of supplying hourly load data, that is governed by the federal tariff. Just as if Duke was charging a wholesale client a rate, that is also a part of supplying electric service, but it is not a part of the commission's jurisdiction. Rather, the commission's jurisdiction is only over utilities that are actually supplying electricity, which Duke is not doing, to the entity in question. I also briefly on the exculpatory clause issue raised by counsel for the commission. The commission here and Direct Energy have extended the specific language of the Ohio Administrative Code that prohibits exculpatory clauses in the event of the negligence of the party, and to make it so like there can never be an exculpatory clause in a tariff. In this case, as commission counsel admits, that is in the tariff. The commission had the chance to review it, and there's been no finding of negligence here because that also is not within the jurisdiction of the commission. At the end of the day, however, the more important factor is that the only reason, even under just a plain reading of the administrative code, the only time there is no application of the exculpatory clause is when negligence exists, and that was not the case here. And I see my time has passed, so I thank you for your time today.
Thank you. Thank you, counsel. We'll take the matter under advisement and you'll be notified of our decision. All right, our last case this morning is 2020-228, the Toledo Bar Association versus Thomas Allen Yoder. For the respondent, Mr. Yoder. Counsel, you'll have to unmute your microphone.
Can you hear me now?
Now we can.
Okay, you can hear me?
Yes.
Okay. My name is Thomas Allen Yoder. I am 68 years old. I have been a very respected member of the Toledo area legal community for the last 42 years. I have had a very varied practice, and in my humble opinion, this entire proceeding against me has been an absolute joke. If I could, I would direct the court's attention, if we could, to the bottom of the findings of fact on page 11, where whoever authored the opinion stated, indeed, while this matter was winding through pretrial proceedings and while respondent was represented by counsel, respondent himself filed a 63-page second amended answer with 34 exhibits after, and whoever the author was, underlying the word after, his attorney had already filed an answer to the same amended complaint. All to reassert arguments in the underlying case as ostensible and to reassert descripers for opposing parties, lawyers, and judicial officers. In this case, respondent did not approve of the answer filed by his counsel solely because he insisted on the over-the-top factual arguments, procedurally incorrect inclusion of materials well beyond the mandate of Civil Rule 10. That is absolutely insane. It is crazy. I filed my amended answer on July 12th. Martin Moeller filed his answer on October 17th. Whoever authored this, I don't know what world they live in, but July 12th comes before October 17th. I said this whole thing has been absolutely unbelievable, and that's just an example of it. And like I said in my objections, if anyone wants to check the veracity of any of the findings in this, they should look to that phrase. Transcript number 355 sets forth what really happened. Mr. Dawson, I think we may be able to short circuit this. Realtor would be amenable to having the respondent's last self-filed answer to the prior complaint for the second amended complaint with his general denials be his testimony. Me, that's fine with me. That's fine, I will stand upon it. I think it was filed on July 17th. I filed a response and answer of 64 pages, and I think I had 34 exhibits to back up all of my assertions. I did not file that to hassle anyone. It was filed. It is 64 pages. It is an affidavit. It has 34 exhibits in which I deny each and every allegation in those paragraphs. It's very comprehensive. It is not, I deny, I admit, and so forth. I said in there that it was very professional, bespeaking my experience that I've had. The case also took a very strange turn. October 22nd, 1919, Joseph Dawson filed a motion before the board, which is quite embarrassing. Mr. Dawson filed a motion and he wanted to have the board deny me calling any witnesses and to deny me calling any exhibits. I cannot imagine when any of you were on the common pleas bench, if someone came in and said, I don't think the defendant should be allowed to call any witnesses or any exhibits, you would take it seriously. I think that this is absolutely a joke. The reason that Mr. Dawson did not want me to call any witnesses is because all 4 witnesses that I called at the, before the panel backed up exactly what I said. September 30th, 2015, I walked in for a very short hearing whereby a drug addicted, mentally unstable mother was going to sign the last of her 3 children over to her parents. I walked in, we had her consent. Half hour later, we walk out. The magistrate made a ruling that the children were in immediate, imminent danger and that they needed to be removed that very day. It is still one of the most stunning decisions I have ever seen in my practice.
Counsel, you seem to be relitigating what happened in the trial court level. That's not why we're here. We're here based on the complaints against you.
We're breaking up badly.
I'm breaking up? Did you say you can't hear me?
Yes, ma'am.
Can you hear me now?
No, I can hear you now.
Okay. Yes. You seem to be relitigating or wanting to explain why you should have prevailed below. That's not why we're here. Can you redirect your focus to why we're here, sir?
We are here because the findings in the report are not accurate. They totally ignored my witnesses. They claimed that I badmouthed the magistrate. My witness testified that the reason that the children were removed was because the magistrate did not like my client's attitude towards him. That is why we're here.
Counsel, do you deny what you're alleged to have said and written and, in any of these 3 cases?
No, I said those. They are all very truthful.
Okay.
Everything I said about the magistrate was absolutely 100%. When we got down to the stage after that, like I said, a poor little girl was taken away by the magistrate. She should not have been. Everything I said about that magistrate is true. My witness backed it up completely. She claims that he acted improperly. He should have gotten a hold of an attorney. He was mandated to get a hold of an attorney and have the attorney check over what happened. He did not follow the rules. As a result, the little girl ended up going through a very traumatic experience, all because the magistrate thought that he was disrespected. There's other things in the findings of fact that are completely inaccurate. Page 10, respondent leapt to the conclusion that the respondent himself was being blamed by Mrs. Dow for the rape, and he stood accused by her of having covered it up. Whoever wrote the opinion did not look at the January 11th, 2017 Get Professional Help email, where in fact, I was accused by Cody Dow of covering up a rape of a 14-year-old girl. She said that her entire reason for being involved in this case was to prevent the little four-year-old girl from being like her mother. And she also threatened to blackmail us. My contention is this whole thing came about because the woman has some very, very serious problems. Problems that I should have, and I was obligated to report to the nursing board. The woman thought that my son was out following her. If she thinks that my son is a private detective, like she put in the letter to the state, to the Bar Association on December 5th, the woman's got some problems. And I have an absolute obligation to report her to the nursing board. She claims people are following her, people are videotaping her. They were not. Like I said, I have an obligation to do that. Going on to the case with Fan Zhang, I did everything right. Mr. Zhang lied to his clients. He told them that the transfer of title to property negated their recorded land contract. I have kept that up for the last 9 years. I solved the problem. I thought that's what attorneys were supposed to do. I have Exhibit WW, which showed that I did everything possible. I have acted as the escrow agent for the last 9 years. I have paid everything out. Fan Zhang lied to his clients and told them that I was stealing money because I wasn't paying the original mortgage holder. I also contend that a lot of this was done through ineptitude. I have sent copies of all of the exhibits to everyone concerned to let them know that I was in fact not stealing the money and I was doing the job that I should have done. One of my contentions is that the Toledo Bar Association has done an in-depth job on this. The exhibit they had, number 34, when it went before the panel, the only thing it went back to was 2012. The Bar Council had at least 5 copies of that recapitulation and never even looked at them. Same thing with the title holding agreement. I contend there was a problem. I turned around and I solved it. My client, Jeff Maris, was in ill health. We were going down to the Big Ten Championship, my son and I. I explained to Mr. Maris that I would hold property in trust for him. He had one son who lived in Washington, D.C. He wanted any money left over. I submitted the title holding agreement. It's in the file that I filed on July 17th. It clearly sets forth 1.7 and 1.8. I submitted it to Bar Council. Bar Council filed several complaints saying that it did not include it. I showed it to him. He then changed the directions and went back and filed against me for having a pecuniary interest in the title holding agreement, which would occur in the year 2026, 15 years after I took this. I contend I have done nothing wrong in this. There were problems that I solved, as any good attorney would do. I saw them. I took care of it.
Counsel, let me direct your attention to the findings of the panel. Professional Conduct Rule 3.5A6, undignified and discourteous conduct that is degrading to a tribunal. And that is in relationship to what you've said and written about the magistrate. Are you saying that what you said, the statements you made about the magistrate were not undignified or discourteous conduct that degraded the tribunal?
They were true. Absolutely 100% true.
Counsel, that's not what I asked you.
Yes, they were degrading, but it was also true. Everything I said about him. Pardon me?
They were discourteous as well as undignified.
Okay, well, I respectfully disagree. I put down exactly what happened. It is not my fault that the man cannot function as a magistrate. He lied. As I put in my opposition, I put the two paragraphs together. My witness, Martha Rywald, backed me up 100%. When he told us that he had talked to Barb Cummins before he removed those children, that was a flat out lie. In my affidavit of prejudice and bias, I put in there that he had lied because he thought Barb Cummins agreed with him. 2 years later, Martha Rywald gets up and agrees 100% with me. Now, I can't help it that the man cannot function as a magistrate, made irrational decisions, lied to us, and so forth. Judge Zimmelman agreed after listening to the tape that there was far too much contentiousness in the courtroom, and it didn't come from me, and it didn't come from Mr. and Mrs. Brooks. It came from the magistrate lecturing us as to our conduct. I don't have to put up with it. Mr. and Mrs. Brooks do not have to put up with it. All he had to do was act like a normal magistrate. You do not pull two children away because you do not like grandma's attitude, period. Now, I didn't create the situation with him. I did not create the situation with Fan Zhang. I walked in for what should have been a 10-minute hearing, and the next thing I know, I'm being accused of rape. My son is being accused of following her, and I had an absolute obligation to report that to the nursing board. Same way with Fan Zhang. If you look at the answer that I filed, I did everything right. Fan Zhang lied to his client.
Mr. Yoder, you've used your time.
Okay, thank you.
Mr. Dawson, if you'll turn your microphone on, we'll hear from you.
Chief Justice O'Connor, Associate Justices, Mr. Yoder. May it please the court, on behalf of the Toledo Bar Association, let me first address a few of the things that Mr. Yoder has said. As is painfully obvious, the reason that the motions in limine were filed was to try to avoid relitigating the matters below. I thought Chair Collins did as admirable a job as he could with giving Mr. Yoder leash to try to present a case and still try to avoid those underlying litigation, which is not at issue. Respondents' essential objections here are that the findings are unsupported. And although the author of the report may have gotten those dates mixed up, what is most critical and most obvious to this court is the manner of that answer. It did not comport with Rules 8 or 10. It was essentially a diatribe with affidavits and exhibits. And rather than go through trying to make some sense out of reinstituting that and raising it at the hearing, I simply agreed, again, as an acknowledgement to the shortness of time, let that amended answer stand, let his testimony at the hearing essentially equate to the denials of the amended complaint. And let's get to the merits of this and be done with it. The panel's analysis and its findings were based on respondent's writings and his testimony. The exhibits alone established the case by clear and convincing evidence. The testimony essentially made the case, established the burden as beyond a reasonable doubt. The panel's determination of credibility, as this court has recognized, is entitled to deference. They saw and they heard the witnesses firsthand. There was nothing that weighed heavily against any of the findings. The panel did not lose their way. Respondent's conduct was the issue, not the merits of the underlying case. And although the exhibits alone met the burden of proof, we later called the witnesses to establish the dissonance between Mr. Yoder's beliefs and the facts as they came out. Two of the very witnesses that he called, both the guardians, magistrate, or I should say Attorney Rewalt and Attorney Bryant, both stated that they did not feel that the magistrate had lied. They did not say that his opinion was unfounded. I mean, it is unsettling to read the transcript and then hear Mr. Yoder's objections. Even his defenses that were unrelated to the underlying cases had no support. I'm only human. I was simply reacting to the aggravation and the irritation. The magistrate's hearing that he's talking about happened in September of 2015. If the court would look at the exhibits, his objection to recuse the magistrate was filed in 2017. There is clearly a premeditation that was involved in these filings and these statements that simply vitiate his arguments that he's simply human and responding in the heat of the moment. Misconduct here was his mistreatment of third parties. The judicial officer, Magistrate Aja, Mrs. Dow, the Thomases, the Zhangs, and the subpoenaed witnesses. In each of these underlying matters, when he was challenged or aggravated or irritated, his response lacked any sense of proportionality, instead focusing on intimidating, burdening, and in short, bullying. Now, I know the court has reviewed the briefs and most importantly, the panel's report. So I won't present the principal points of the mistreatment of each of these third parties unless you'd like me to.
Counsel, would you address one of the recommendations is OLAP, an OLAP evaluation and then compliance in the event that there's found to be a need for an OLAP contract, correct?
That's correct, Your Honor.
All right, can you expound on why that's necessary here?
Well, in this case, and I concededly, it's a less common part of this matter. There's no evidence of depression. There's no evidence of substance abuse. So why do it? And it's because of respondents' dissonance, the dissonance between his beliefs and the dissonance with the facts as they were established by these witnesses who testified. Further, in addition to that, it's his deviation from the professional acumen that he's clearly shown in the past. He's been at this for 40 years. He's been involved in litigation up and down the various courts in Northwest Ohio, federal and state. How does that experience and that background rationalize the filing of the pro se answers in this case that did not comport with Rule 8 or 10? How does that background comport with the very objections that were filed with this court? It's as though Mr. Yoder sat down with a dictating machine, dictated the caption, and then sat there and did a stream of consciousness for an hour and a half and concluded it with the certificate of service. There's no compliance with this court's rules for...
Counsel, let me ask you, was there testimony that up to this point, Mr. Yoder was professional and the antithesis of what he was exhibiting during this disciplinary process?
Your Honor, I think Judge, bear with me, but I think Judge Zimmelman spoke to that, that she had known Attorney Yoder before, and his allegations that he attributed to her, the statements that he attributed to her, were entirely unfounded. She did not go into any greater detail, and frankly, we didn't present any other witnesses that would have established the difference between what we are seeing here and in those cases versus how he presented himself previously. Mr. Yoder has been an acquaintance, and I'll not speak further. I did not testify. We believe that the panel took the evidence that was before it, and it is, again, worth reviewing the descriptions that the panel submitted of the various testimonies that were presented in paragraphs 8 through 13, I should say 14. They stand in stark contrast to what Mr. Yoder claims that they said. The aggravating factors that were reviewed under Gov Bar Rule 5, Section 13 by the panel: disingenuous claims and recitations, dishonesty, that would be B2. Essentially, it was replete in this case, the reckless disregard of truth. That was endemic to all three of these underlying events. And not coincidentally, that phrase comes from Rule 1.0 defining fraud, one of the alternative prongs for fraud. And that's Mr. Yoder fraudulently described the magistrate, he fraudulently described Mrs. Dow, and he fraudulently described his authority to file this claim in Sylvania Municipal Court after it had been pending before Judge Jennings, again substantiating the finding that his filing of that case was entirely frivolous. His refusal to acknowledge misconduct, that's certainly on display here. His claim he's just having a bad attitude and responding and reacting to all the aggravation he's had to put up with does not hold water. There's nothing, and I've said this in one of the other briefs, there's nothing in this process that gives Mr. Yoder pause. Multiple violations, 8 different rule violations. Goodness, we started out with 19 that we were alleging. The 6 were dismissed by the panel. And it again underscores some of what's going on here. Mr. Yoder spent time talking about the trust agreement when that allegation was dismissed. Vulnerability of these third parties. The magistrate never had an opportunity to defend himself. And what is more damning for Mr. Yoder in this case is that he filed the motion to recuse the magistrate in July of 2017. If you look at exhibits 14 and 15, he's still at it. In February of 2018, he is again reasserting that the magistrate lied and that his decisions were unfounded. In mitigation, he has no prior history of discipline. That's undisputed. Cooperation, I have it in question marks when you look at what he filed and the manner in which he attempted to present his case did not simplify things. It only exacerbated the time and the efforts that were required by everybody to deal with this. The panel accurately concluded the aggravating factors here overwhelmed the mitigation. This case does call for actual suspension. If you look at simply the abuse of a judicial officer alone, that warrants time off. When you add in the misconduct, the attacks on these other individuals, on Ms. Dow, including her husband. He was added into the letters to the Ohio Nursing Board too. Mr. Yoder never had an opportunity to see them acting as nurses. This was simply a gratuitous attempt to affect them being out of the litigation for the benefit of his clients. When you add all that in, the sum total of all that misconduct compels an actual suspension. Now, the relator requested 2 years and 6 months stayed. Frankly, that can be rationalized. If you give time off for the magistrate of 6 months, time off for the Dows for 6 months, time off for the Thomases for 6 months, you can see where we were coming from. But the panel analyzed this case based on prior cases, as it should have. It recommended 2 years with 1 year suspended and conditions, including the referral to OLAP. The cited case law included indefinite suspensions where the respondents had no prior discipline. Indeed, in Pullins and Don Chats, both of those attorneys had no prior history of discipline. I will simply add this as a matter of perspective. We certainly abide the recommendation. We did not object to it for this suspension, but this court should remember that both the Dows and the Thomases asked that Mr. Yoder be disbarred for his attacks against them. The panel's rationale was not to punish, but to inform him that the conduct was wrong. The deterrent effect of that is the protection of the public. Even abuse to third parties will not be tolerated. There's also a deterrent portion for him in that the stayed portion of the suspension would be a reminder that there would be consequences for future misconduct. And we've already discussed why the referral to OLAP should be made for unaddressed mental health issues. In conclusion, this case underscores that mistreatment of adversarial third parties, as well as judicial officers, clients, and staff members, should not be tolerated by our profession. Based on the panel's report, the board's recommendation is uniquely tailored to this case. They've complied with the requirements in GovBar Rule 5, Section 13, in presenting the recommended sanction of a 2-year suspension with 1 year stayed and conditions, including referral to OLAP. They did so by weighing all the evidence, by considering the precedent established by the prior decisions of this court, and by considering the aggravating and mitigating factors set forth in that section as presented by this case. This evidence, I should say the evidence in this case, clearly and convincingly establishes the violations found by this panel. Likewise, the recommended sanction is warranted and fits the case. Respondent's objection should be overruled, and the recommendations of the board, incorporating that of the panel, should be adopted by this court. We thank you for your time.
Let me unmute myself. Mr. Yoder, you've used your time. You may take 1 minute.
Again, it was 2 situations that I did not create. I walked in, like I said, for a 10-minute hearing, and the next thing I know, everything went south.
Counsel, could you focus your time on the OLAP recommendation?
I have absolutely no issues whatsoever. Like I said, I have no problem. I have been a respected attorney in the Toledo area for the last 42 years, had absolutely no problems. I'm not sure, and I'm being very honest, what else I could have done in these 2 cases. I mean, I didn't create the situation with Van Zang lying to his clients. I'm the one that solved the problem. The same way with Magistrate Adja. I do not have to sit back and put up with him and his abuse and have Mr. and Mrs. Brooks put up with his abuse and the things that he did to them.
Thank you. Thank you, counsel. We'll take the matter under advisement. You'll be notified of our decision.
Thank you.
Marshall, will you adjourn court, please?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.